And welcome everyone to a special edition of the Smart Money Circle. I'm Adam Sarhan. With me today is an asset protection attorney, Blake Harris, who has a lot to share, and I'm very excited for today's conversation. Blake, thank you so much for taking the time, and welcome to the Smart Money Circle.
Thanks for having me on the Smart Money Circle, Adam. Great to be here.
So, Blake, I always like to begin. Can you tell us a little about your story and how you got to where you are today, please?
So happy to. I have spent my entire practice, my entire career helping high net worth individuals protect their assets from lawsuits and other types of litigation. I started my practice over 10 years ago when I was in Denver, Colorado. My office was just a few blocks away from Barry Engel's office. Barry was the attorney who back in the 1980s wrote the initial Cook Islands Trust International Trust Act. He was a mentor of mine for many years before he passed away a few years ago. Since then, I have traveled to dozens of different countries, met with trust companies, protectors, CPAs, investment advisors all over the country, building a global Rolodex, which we use for our clients to help keep their assets protected from lawsuits and litigation. We're very niche focused. We focus exclusively on offshore asset protection, and we work with clients all throughout the world.
I love it. How did you get involved in that line of work as opposed to going into other areas of law?
So it is a very niche effort. Excuse me, it is a very niche area, and I was influenced heavily by my mentor Barry Engel. There's also a story I tell of back when I was in kindergarten. Our teachers would collect $1 from us each day for lunch. Our parents would give us $1, and there's a way of teaching us to pay for our own lunch. But I learned that if you forgot your dollar, the teacher would still give you lunch. So after about 30 days of forgetting my dollar, the teachers contacted my parents and said, "You need to send Blake with $1 each day." Well, they said, "What are you talking about? We've been sending Blake with $1." Then they go into my cubby, and what I consider to be an improper search and seizure went into my cubby and took out $30 that I had accumulated. And that time I realized making money is has some importance to it, but really protecting and holding onto the money is really the most important thing. So I got into this career and very early found this was something that sparked an interest with me. I come from a family of litigators. Everyone in my family is a courtroom attorney who goes and argues in court. I'm one who prefers to avoid that argument. And the way we do that is we structure our client's assets in a manner so that if somebody tries to take it away, there's really no economic incentive for them to drag our client into court because the assets are all controlled by a trustee and a bank that are beyond the reach of the US court system. So I'm very much a peacemaker, and that's what we're able to do, give our clients peace of mind and allow them to avoid a lot of litigation.
Wow, what a great story from kindergarten. I mean, I've heard some other stories, but I don't think going back to kindergarten. So I guess it's some kind of divine type of route for you. So
Go
it,
ahead.
I was going to ask you about your company. Can you tell us a little about your practice, what you do, how you help people, and go in a little bit more detail, please?
Sure. So myself and I have another attorney who's a partner, as well as a team of paralegals who support us. We start with an initial consultation when a client contacts us that we don't charge for. During that time, we do an analysis of the client's current situation. We want to understand first what assets they have, and then we will look at what assets are already protected. You get certain homestead protection depending on what state you live in, retirement accounts generally come with some level of protection, insurance, annuities, those already come with a level of protection. Then we look at what assets are unprotected. And if the clients have at least about $500,000 or more in unprotected assets, we will generally recommend setting up an offshore trust to hold those assets. The offshore trust is a very flexible tool and that it allows clients to add and remove property from the trust. They can amend the trust, they can dissolve the trust. But if they're ever sued or go through a divorce, the assets in the trust can remain intact. This gives our clients, number one, peace of mind that they're not going to be taken advantage of by a legal system which has eroded significantly over the years. And they're also going to be able to better leverage a settlement. They can negotiate better by telling somebody who's suing them, well, not only is there some weaknesses in your case, if you proceed and actually get a judgment, that judgment is not going to be collectible. And once we've done this, it gives our clients the ability to pay much more reasonable settlements and operate their business without fear. And that's a very important thing. When you're running a business, you don't want to be behind the eight ball of fear. You want to be confident how you're running and growing your business. And that's what we give our clients, confidence, peace of mind over their assets.
I love that. Now, what size of assets or I guess net worth is appropriate to start the conversation.
So the biggest misconception that I come across in the asset protection world is that asset protection is only for the super wealthy, and this is simply not true. And I'm going to explain with a quick example. Let's say that we have two clients. We've got our first client over here worth $2 million, and then our other client over here worth $200 million. If both clients are sued for $5 million, there's going to be two very different strategies. The client with $200 million, my advice is make no settlement offer, hire the best attorneys in the world, fight this case as hard as you can. And if you end up losing and have to pay a $5 million judgment, it's not going to have any real effect on your standard of living. On the other hand, the individual with $2 million, I'm going to tell them you need to talk settlement and talk settlement right away, because if they proceed with this case and they get a $5 million judgment against you, that could have devastating effects on your standard of living and quality of life. The majority of our clients have somewhere between about $1 and $10 million in assets. We do have quite a few clients whose net worth is a little bit under $1 million. And we did bring on our first client whose net worth is over $1 billion earlier this year. However, the majority of people who set up an asset protection trust have somewhere between about $1 and $10 million in assets. Those are the people who can really benefit the most from having some settlement leverage. And the majority of lawsuits being brought are actually being brought against individuals with under $2 million in assets.
Wow, that's really good to know. Thank you for that. What about timeless lessons you see people make with respect to setting up a trust and doing protection? What are three or four, as many as you want to give, good things that people do when there's going into that world?
So the best thing they can do is start soon. If you can create your trust and fund it before there's any threat of litigation, that is going to get you the best results. Also, taking advantage of other exemption planning, such as the homestead retirement accounts that we mentioned, that is good planning as well. But really, the key thing you can do to give yourself a leg up in the event of a lawsuit is to plan well in advance. In some cases, after a lawsuit, after some issue has begun, it is possible to create a trust and give yourself some room to push back, some ability to mitigate damage. But really, for the best results, get everything set up, get the trust established, get a foreign bank account opened under the trust. And if you can do this all before any lawsuit arises, that will get our clients the best result.
Okay, wonderful. And how about mistakes? What are some mistakes that you see people make? It's that pattern, right? When they either, I'm assuming the first one is not to do it, but so anything else you want to share by all means.
Well, ex exactly. Not doing it or putting it off too long, waiting until you've already been sued or waiting until a court has already frozen your account. It may get to the point where it's too late, or it's so late that while some damage can be mitigated, you're definitely not getting the best possible result. Another common mistake is setting up the wrong type of trust. There's more than a dozen international countries, more than a dozen domestic jurisdictions that allow you to set up an asset protection trust. But the problem with a domestic trust is that a U.S. court can break it. Under Article 4, Section 3 of the U.S. Constitution, every state must give full faith and credit to the orders of every other state. So let's say you've created a Wyoming trust, but you're sued in Florida. Somebody gets a judgment against you in Florida. Under federal law, that judgment's technically supposed to be enforced. And we have seen several times where domestic courts disregard domestic trust. So setting up a trust in the United States, I'd say it's probably better than doing nothing. But if you want real asset protection, you need to set up a trust which the U.S. courts cannot break. The next thing is making sure that you choose the right jurisdiction offshore for setting up a trust. As I mentioned, there's more than a dozen different options, but there's really only 3 countries with good codified asset protection trust laws: Belize, Nevis, and the Cook Islands. Belize has a great law in place, but it's otherwise not the ideal place to do business. There's an instability with the government, with the banks. The regulators can be a little bit unpredictable. It's not my first choice of places to set up a trust for my clients if we can avoid it. We do some business in Belize. I go there frequently as well, but generally we prefer clients that set up a trust in either Nevis or the Cook Islands. Both these countries have great laws in place. Both of them have good governments. Both of them have a judiciary that generally supports it. The difference, though, is the government in Nevis has grown a bit hostile to the industry. They have on several occasions threatened to introduce legislation which would greatly water down the asset protection business. Nevis has been making a lot of money selling golden passports. They're just not as committed to the asset protection industry as the Cook Islands who has never and probably never will sell a passport. The asset protection industry is vital to the economy of the Cook Islands. And that's the reason that for 99% of our clients, we establish offshore trust in the Cook Islands.
Got it. Makes sense. And then what about, let's talk the details a little bit. So somebody has a trust. Can you walk us through, educate us a little bit on how that works? So you have an offshore trust in the Cook Islands, for example. You put money there, and then what happens when you want to take money out? Who's in control of it? I'm assuming there's a political climate that's favorable in Cook Island, so I wouldn't have to worry too much about that. But Belize, maybe that's a question mark, or some Panama, that might be another question mark. So you want to find somewhere where it has a good political environment. But what happens to the money? Let's say somebody passes away, next of kin. How does that all of that work?
So the jurisdiction that you want to use for creation of the trust is very important. We picked the Cook Islands for several reasons. One of it is the political stability. Cook Islands, in conjunction with New Zealand, is one of the most transparent and honest places to do business. There's very good trust companies. They're very well regulated. The trust companies that we work with have been in business for decades and manage billions of dollars in assets for some of the wealthiest and most powerful people in the world. These trusts are better supervised than US-based trust. Once you create the trust, if you want to get money out, you can always get money out. You simply send a request to the trustee, and then about a week later, they will wire you money from your offshore account to your personal domestic account. If you pass away, the trust document will state who the successor beneficiary is. So upon your passing, your children can step in and receive distributions from the trust. The only time that you would be prevented from getting your money is if the only reason you requested a distribution is to satisfy a court order. So if a court has put a gun to your head and said, bring back $1 million from your trust, you're going to say, yes, I will comply with the court order. But then the trustee, upon realizing that you haven't sworn under penalty of perjury that you're not acting under court order, the trustee will withhold the distribution. So you're in full compliance with the court order. The court's not going to hold you in contempt as long as you are doing your best to comply. But the foreign trustee will still be there to safeguard your assets to make sure that no third party intercepts any of your money.
Interesting. So when you set up a trust, what about the tax consequences and or ramifications for people to consider?
So the trust is tax neutral. It does not increase your taxes. It does not decrease your taxes. You do have to report to the IRS that you have an offshore trust, and we provide our clients a detailed memorandum on how to complete those reporting requirements.
Interesting. And then what about, I guess, problems that could arise that are most people don't know to ask the question, or to look in that direction? What type of problems could arise when people are trying to protect their assets overseas?
So one very important aspect to consider is who you work with when creating an offshore trust. It's a very technical area where the laws and the rules are constantly changing. So you want to make sure that you work with a law firm that is dedicated just to this area of the law. It's very unlikely that you're going to have an attorney who can keep up with the changes in this area of the law and keep up with other changes in areas of other law. So finding a specialist is very important, but it's also very important that you work within a law firm. That way all communication remains protected by the attorney-client privilege, which is absolutely vital in the event that there is a lawsuit. So you want to work with the right law firm. You want to work with the law firm that specializes in this area. My firm, we have been told by Southpac, the leading Cook Islands trust company, on several occasions that we create more of these trusts, that we register more of these trusts with them than any other law firm in the world. As of right now, we've never once had a client lose a penny from a trust. Now, we have had clients take money out of a trust to satisfy a settlement by their own choice, but we've never had any forced extractions from one of our trusts. And I think that just goes to our years of experience and dedication to this one area of the law.
Love it. And then what about, so it's basically nobody put their hand in their cubby and forced the money out of them without the consent. That's what you're saying.
Correct, exactly. We've had times where clients by their own will gave some money from their cubby, but nobody has had that money taken without their consent.
Got it. And then what about if somebody wants to break a trust? How does that work?
So if somebody wants to break a trust, they can try, but they're probably not going to be successful. The case law in the Cook Islands has shown over and over that if you go to the Cook Islands to try to break the trust, you're unlikely to be successful. And because of this, very few people will even go try. In the Cook Islands, you cannot bring a case on a contingency fee. So somebody here in the United States who had a free attorney is going to have to go and dish out tens of thousands or even maybe hundreds of thousands of dollars to bring a case into Cook Islands. That right there eliminates 90+% of people from bringing a case into Cook Islands. Those who are not prevented by financial means will likely be stopped by the realistic outcomes, the realistic chance of their outcome, which is very small, because they have to then win their case by a standard of beyond a reasonable doubt. In the United States, to win a civil case, you need a preponderance of the evidence, just 51% to 49%. In the United States, to win a criminal matter, to put somebody in jail, you have to have a standard beyond a reasonable doubt, 99.9% basically. That is the standard that the Cook Islands uses for civil matters. So it becomes a very hard burden of proof. In the Cook Islands, you can't amend a case either. The United States, you can dig into someone's personal affairs, figure out what's going on, and then change the reason that you're suing them. In the Cook Islands, you cannot amend a case. You have to go back and restart the case. And chances are, by the time you do that, the statute of limitations will run and you're not going to be able to break into the trust. So there's so many burdens. There's so many hoops to jump through for a plaintiff that most of the time plaintiffs will either drop their case and not pursue it at all, or they'll just say, give us some settlement offer and we'll agree not to pursue this case any farther.
Gotcha. And then how about if the client wants to break the trust?
If the
Would there
client
be?
wants to,
Yeah.
if the client wants to break their own trust, they can do that. That's simple. Just tell the trustee that you want a complete distribution of the funds. They'll wire the money to your personal account. They'll transfer real estate back into your personal name. And at that point, the trust will be empty and it will disappear on its own.
Gotcha. Beautiful. Any questions, Blake, I didn't ask that you think we should cover before we wrap up for today?
So just want to quickly go over putting assets into the trust. So
Sure.
step one, you hire an attorney. Step two, the trust gets registered. Step three is then putting money into the trust. When we create a Cook Islands trust, we'll also open up an offshore bank account, typically in Switzerland. We have open bank accounts for clients in Switzerland, Liechtenstein, the United States, Cook Islands, and Panama. Switzerland is my favorite jurisdiction to open accounts for clients for several reasons. Number one, you get access to a wide variety of different investment options. You get access to excellent, crisp Swiss customer service. You get access to some of the most stable banks in the world. And you have diversity of jurisdiction by having the trustee in one location and the assets in a different location. It gives you the ability to more easily move them around in case a plaintiff actually goes overseas to try to attack the structure. So first we open a bank/brokerage account under the trust. Next, if there's real estate that's not protected by a homestead exemption can be held in an LLC, and that LLC can be backed by the trust. Once real estate is in the trust, it does get a level of protection, but for better protection, we may advise clients to equity strip that real estate, either mortgage it or sell it, and then put the proceeds into an offshore account. The same is true for business. A business interest can often be held by the trust, or that business can have its assets removed and then put those assets into an offshore trust as well. The trust can hold stocks, bonds, gold, silver, cryptocurrency. Pretty much any asset that you can own, Adam, can also be protected.
I love that. And then what about let's do a cost benefit analysis type of a thing between a US trust and then an offshore trust. What would some of the pros and cons be for each?
Well, I mean, in terms of cost, a offshore trust is going to run you an average of around maybe $30,000, whereas a domestic trust may run about half of that. So the benefit of the domestic trust is it's going to cost you less to set up. The benefit of the offshore trust is it works a lot better in the long run. In terms of the leverage you're going to get to negotiate a settlement, you have much more powerful bargaining power by being able to tell someone that no matter what court order you get from the US, your trust is still not going to be compromised. So a domestic trust is considered kind of like a speed bump. It can slow someone down. It can make it a little bit more costly for a plaintiff to break in, but you don't get that real solid asset protection that you get with an offshore trust. So in the short run, the domestic trust is going to be the better option. But in the long run, you get a much better value from the offshore trust because the offshore trust just is much harder for a plaintiff to break into, and the case law backs it up. And plaintiff attorneys learn this quickly and are much more willing to take a settlement offer with an offshore trust than a domestic trust.
Got it. Well, Blake, this has been absolutely fantastic. Anything else you want to cover?
Can
Or do we
I
hit?
put my social medias can I share my social media now?
Yeah, please. Yeah, the more you, I want, my next question was after that was how do people get in touch with you? But yeah,
How,
please.
how do you get in touch with me? Well, I enjoy talking about asset protection. I talk about it all day, every single day. I have hundreds of thousands of followers across my various social media channels, TikTok being the biggest of those, but we're also on YouTube, Facebook, Instagram, X. We post videos a few times a day talking about asset protection. I share information about my travels, about business in general. One of the cool things about this position is I get kind of an inside look at various different industries, and I see what industries are booming, what industries are sweating, what industries people are worried about, and I share that knowledge with my followers. Or you can just visit my law firm through our website, blakeharrislaw.com, fill out a contact form, and a member of our firm will get in touch shortly to discuss how we can help put you on the road to peace of mind over your asset protection. There are millions of lawsuits filed every single year in the United States. There are billions of dollars ordered to be paid out in judgments every few days, often for bogus or BS claims. The last thing we want is to have a client who ends up paying a settlement even though they weren't actually harming anybody. It becomes so expensive to defend a case that individuals will just pay a settlement. This is essentially legal extortion, which I don't want it to happen to me. I don't want to have happen to my clients. And that's what we do. We give our clients protection from a legal system that has been compromised over the years.
Gotcha. That makes perfect sense. Okay, one more question for you since you're on a roll here. What's the best piece of advice you'd like to give the audience or your 20-year-old self?
Best piece of advice I would like to give to the audience or to my 20-year-old self? Well, I'll tell you, I've thought about what I would say to my 20-year-old self, and it's actually good advice for the audience as well. And that's to calm down a little bit, relax. I have always been a fairly high energy person. I was one who finished college in 3 years. I started my own law firm only a few years afterwards. I'm one who still takes calls early in the morning until late into the day, evenings and weekends as well. And I don't know that my habits in that regard are going to be changing anytime soon. I'm pretty well formed in the way that I do business. But as I've gotten older, I've gotten better about relaxing, about not being so hard on myself. And because of it, I feel healthier. Because of it, I think I'm going to live longer. I'm going to be able to have more time that I spend with my kids and future grandkids. I'm going to be able to work more and produce better. And so I would say relax a little bit. And if protection of your assets helps you relax, well, then go protect your assets.
I love it. I love it. I finished college in 3 years also and happened to be that high energy kind of go, go, go. Started my own business, similar story right after grad school. So I love it. Blake, thank you so much for taking the time and hopefully we'll have you on again soon. This was fantastic.
Adam, thank you so much for having me. You have a great one.